Jones versus Cattaraugus-Little Valley Central School District.
May it please the court, Virginia McMichael. For the appellant, Brittany Jones, I'd like to reserve 3 minutes for rebuttal. First of all, I would like to thank the court. As a Pennsylvania attorney, this is my first time here in the New York court, and I appreciate your granting my application for admission pro hac vice.
Most welcome.
The waiting period between February 14, 2019, the effective date of the CVA, and August 14, 2019, when the window opened for filing revived claims, is neither a statute of limitations nor a condition.
So here,
preceding.
I'd like you to address this. I'm a little
Sure.
troubled by a conclusion reached by the Second Circuit panel that the revival of the claim is as of the effective date of the statute rather than the first day of the revival period. And I'd like you to address how the statute itself supports that conclusion, because I cannot read it that way. I'm having great difficulty.
Your Honor, I think the answer is in the statutory language. And as, of course, as this court's well aware, that's the first place you look to interpret a statute.
Yes.
The legislature in Section 2014 said that prior claims that had previously been time barred,
Yes.
because they were to have been brought within a year and 90 days from her turning 18,
Right.
are hereby revived.
Yes.
And hereby revived, it does, as of the effective date of the statute.
It doesn't say that. That is
It
my
doesn't,
problem.
but
No,
that-
no, let's stay with the text. We're on the text. It says, hereby revived, comma, and action thereon may be commenced not earlier. And then it sets out the time frame. And even if this was ambiguous, the legislative history is very clear that there's a revival period. And that period is set out in this statute. It's not the effective date of the statute.
Well, the claims, so I envision it as if
Yes.
it's a door. So the
Okay.
door was closed on pre-existing
Yes,
claims.
yes.
And that door opened
Yes.
on February 14, 2019, when
And how could one
statute-
walk through
So
if it's the door?
it's open, it's open
Yes.
until it closes at August 14,
Well, if that's what they meant to
2021.
do, it would be initially, not now, right? Initially, it would have been an 18-month statute of limitations. That's not what they did. They're very clear. And action thereon may be commenced. Hereby revived is simply declaring that they are reviving. You have to go through the rest of the sentence to understand what's the period during which it is revived.
Well, but if they had intended
Yeah.
the claims to continue to be time barred
Yes.
until August 15th of the same year, 2019, 6 months later, they would have said claims will be revived as of then. They
Then
said
what
hereby
effect
revived.
do the words "may be commenced not earlier than 6 months after" have? How are you giving any effect to them under your reading?
Well, the reading is that the claims were not, were
I take it you-
revived, but it was a procedural provision
Okay.
for filing.
So it has no consequence with respect to the viability of the claim at all? So is it your view that if, well, let me ask this. If, and I think there are a couple cases like this, Carlino, for example. So if a defendant moves to dismiss on the ground that the claim was filed prior to the 6 months, does the court have power to dismiss that?
Yes.
Okay, and why not after?
Well, the distinction is, and it happened in 2 cases.
I know.
Carlino and Geis.
Yes.
And the distinction, I think, the key distinction is it a dismissal with prejudice or a dismissal without prejudice? Because as the court's well aware, a statute of limitations is a final time bar. And if you bring a claim that's barred by a statute of limitations, the court is going to dismiss it with prejudice.
Well, let me
Okay,
ask you
so-
this. If indeed, and you've adopted the Second Circuit's view, it hereby revived means as of the effective date of the statute, not the revival period that's set out 2 words later, right? It's the effective date of the statute. Why, during those 6 months before one can file pursuant to the now legislatively adopted revival period, why isn't that claim subject to the existing statutes of limitation?
Well, I think they would be subject to well, that's why I think it comes into the hereby revived language, because if it were still subject to being time barred by the prior statute of
Yes.
limitations,
Right?
they would have been time barred permanently time barred by the original statute of limitations up until August 14 of 2019.
Right.
In which case, those cases that dealt with premature filed claims like ours would have said, oh no, that's dismissed with prejudice because the prior statute of limitations were still in
Any
effect.
case that was brought after the statute of limitations, that would have happened, right? Let's say before the statute was passed, I bring a claim, there's no revival statute, I'm going to be dismissed with prejudice if I'm outside the statute of limitations. The revival window opens, I can now bring that claim again, even if I was dismissed before with prejudice, right? So why isn't it the same effect in that window period? The old statute of limitations period exists, you get dismissed. If you have time and the window's open, you can bring the claim in the window.
Well,
You can bring it later, like you can bring it in the 18
well,
months.
you would get dismissed, except it would be a dismissal without prejudice.
But I think the point of Judge Garcia's
Okay.
question, though, is that it doesn't matter if it's dismissed with prejudice or without prejudice, because when the window opens, you can file the claim. You have a statutory authorization to do that. So why don't we just say the statute of limitations was, foreclosed the case until August 14th, 2019, or August 15th?
Well, then, why would they say is hereby revived?
But
Wouldn't they
again,
say
you're taking it out of
revived?
context, hereby revived and. It doesn't say hereby revived, period. It says hereby revived, and then it sets forth the period for the revival. But let me ask you this. Maybe this is why I'm not understanding fully this argument or not fully appreciating the Second Circuit's conclusion on this. What do you understand revival means?
It means that claims that were previously time barred by
Okay.
operation of the existing statute
Does that
of
mean the
limitations.
claim was extinguished?
It is statute of limitations don't extinguish claims ab initio. It's not like it evaporated. It just prevents you from bringing an action on that claim after the statute of limitations.
Okay, well, why can't we look at the sponsor's memo, which I think is pretty clear, right? If we're saying we can't figure out what the language means, although I'll take issue with that, because look, they have to say hereby revived, because otherwise the claim was dead. Right? You agree with
Precisely.
that. Initially, it was dead, so it has to be revived. The sponsor's memo says, such a revival can only take place within a 1-year window, which commences 6 months from the effective date of the act, and any revived civil actions brought during the 1-year window shall not be dismissed. I mean, I think it's pretty clear that they have these boundaries of 1 year, and unfortunately, you fell out of it.
So essentially, what would mean is that the defendant's affirmative defense that our claim was barred by the statute of limitations is saying not barred by the revival statute of limitations,
bring it
but by the
within-
prior statute of
No, but
limitations?
if you bring it within that 1-year period, it can be revived. But if it's outside of it, you can't.
Because
Then it remains a dead claim because the original statute of limitations expired.
That's certainly an argument. We're saying that's
What
not the way the
to
Second
you-
Circuit read the language.
Counsel, to you, what is the 6-month period?
The 6-month period is from February 15th.
What is the effect of it?
The effect of that is that the purpose of it, first, let's start with the purpose. Why would you have that 6-month window? And the purpose of it was that the legislature knew there were going to be a lot of claims coming in. And we've certainly seen that. Every time I update, there's a new decision. And that gave the court administratively an opportunity to be prepared for the onslaught of cases. It also gave plaintiffs who were dealing with claims that accrued many, many years before to get their ducks in order to present their proof. And in other words, instead of saying, oh, you got to bring your case tomorrow, you've got less time, they gave them a little bit more opportunity.
Yes, but if that's what they meant to do, they could have started at the date that they started it and added the 6 months at the end.
The end.
And they didn't do that.
Well,
So the 6 months is not about plaintiffs. It is as clear as day, it's about the court administration. Because it requires training, it requires the chief administrator to prepare things. It is just as clear as day that was the interest.
Well, I think some of the case law that we've cited in the brief does talk about waiting periods are often designed to give plaintiffs an opportunity to.
But I don't think you've pointed to anything that is similar to this in that there is language which revives a cause of action, and I think the question is, does it revive the cause of action effective the date of enactment, or does it revive it 6 months later, right? But I don't see any other examples, and correct me if I've missed them, where you have this peculiar combination of language which could be read to revive it on the date of passage, but you also have it connected to a clause that says wait for 6 months. Are there other examples of this kind of structure that you can point us to?
I'm not aware of one.
I couldn't find one either.
Yeah.
So if we're trying to figure out how to square the straightforward, I think anyway, language hereby revived with the clause that comes after, doesn't the intention to create a 1-year window matter? It seems pretty clear that that's what the legislature was looking to do, but I think under your reading, there's an 18-month window. Am I wrong about that?
Well, there's several cases, and they're cited in my brief, if I can find the right page, where often in parentheticals, quite frankly, they talk about the revival window being from February 15th of 2019 until August of 2020 and then 2021.
But the effect of your position, I think, is that the window is extended by 6 months longer than what the legislature appeared to have been trying to do. Didn't it look like the legislature was trying to do first a 1-year period and then it added a year, I believe? And you want us to extend that by 6 months, I think.
Well, I guess it depends upon whether you see is hereby revived to have.
Yes, but
you know,
your reading
yes.
would mean that it is extended by 6 months where there is not a motion to dismiss. I take it your view is that if the motion to dismiss had been brought within the window where you could have cured, that a dismissal without prejudice would have been proper. Is that right?
Yes, just as
Okay.
in the Geis and
Right,
Carlino
okay.
case.
And
dismissal
so,
without-
so I think your position is that if it's not brought until after that window closes, that effectively the start date has been pushed back 6 months so that we have a 18-month or 30-month, depending on whether it's 1 year or 2 window. Is that right? That's hard to square with what it looks like the legislature was trying to do.
I understand the question. I just think that if you look at cases that have construed that, they do talk about
So
the
is
date
it-
beginning in February. I mean,
Okay,
that's-
so are we looking at a
far.
circumstance where the legislature meant to do one thing, but the plain words suggest that it actually did something different?
That's certainly how the Second Circuit has interpreted it, by saying that the hereby revived means that it started on February 15th.
But if one looks at that and says, at a minimum, there's ambiguity. I think it's clear, but I think it reads the other way, but okay. But then it's at a minimum ambiguous. Now we're left with the legislative history. Judge Singas has already read it to you. It's very hard to see it your way, that it's revived as of the effective date of the statute.
So that anything filed prior to August 15th of 2019 was barred by the prior existing statutes of limitations.
But but again, I think you're stuck with the problem that even if one says, okay, it's revived as the effective date, because the statute of limitations that's tied to the revival has not yet begun, the clock has not started to tick for 6 months, you're left with an existing statute of limitations, and therefore you're still barred. Unless you want to argue or think that one could argue, I don't know that it's preserved, but you're free to argue it to us, that it's revived as of the effective date of the statute, but that meant the old statute of limitations starts clicking again and is in place until the new one picks up.
I think that the cases where they dismissed it without prejudice for
Yes.
filing prematurely
Yes.
would suggest that the claims that were filed in that 6-month window weren't time barred by the prior statute. I mean, I understand their lower
subject
court
to the
decisions.
Or subject to the prior statute of limitation starting again, because it's revived, and the statute of limitations is also revived and starts again.
I'm not sure I understand the question, Your Honor.
Well, yes, if you say it's revived, the 214G statutory 1 year, then 1 year, now 2 year, statute of limitations doesn't start clicking yet, it's not in place for 6 months. During these 6 months, something is in place, unless you think it's in the ether and nothing is in place. Then there are statutes of limitations for these kinds of claims. Right? So I asked, are you in part perhaps arguing that for those 6 months, the old statute of limitations start anew and apply to those claims that are filed during those 6 months?
Well, but didn't those statutes become irrelevant as of the date of revival?
That's what I thought.
On the new
your-
action
from
in
your
February?
papers- From your papers, I thought
That's
your
my-
argument was
Position.
the new statute had 2 features to it, a start date and a stop date. The start date was not a statute of limitations. The stop date was a new statute of limitations for these claims that were revived as of the effective date of the statute. I thought that's what your argument was.
It
Did I
does seem to.
understand that?
They don't, the claims don't become, that door opened in February, and it didn't close again until
You couldn't
2.5
walk
years
through it
later.
for some sort of claims processing reason right away,
Well,
but that the statute of limitations that applied to these revived claims was the new one in the statute. I thought that's what your position was.
yes, that's the argument that we're making, that the prior statute of limitations became irrelevant, ineffective as of the enactment date of the CBA.
And that's contingent, though, I think, on whether hereby revived, or is it herein revived, hereby revived
Hereby
stands
revived.
alone.
Right.
Or whether it's modified by the "and" phrase that comes after it, right?
Right.
Can I ask just one
Yes.
question? If a plaintiff had brought an action in 2018, before the statute's even, they're time barred, they get dismissed with
Correct.
prejudice in 2018. When this window opens in August, can they bring a claim?
Yes.
So what's the difference with or without prejudice if you get dismissed in the 6 months? It would have the same effect of you bringing a claim before the revival period. It would have the same effect as you bringing a claim in 2018 if you brought it in the 6 months. You get dismissed with or without prejudice, as long as you have time on the other end, the 2 years or whatever, you can bring the claim.
Well, but you run into a situation like what happened here, where they delayed for 2 years,
More
so
likely
we
to run
didn't know.
into that, the more people file in the time they told you not to file, because it's going to take more time for these cases to wind through because they're not prepared for them yet. So you're filing in the 6-month period that says you can't file because the courts aren't ready for it, and then you're saying, oh, it's unfair because it took you too long to decide this motion, and now we're out of luck.
Well, what happened here is that the school district made a strategic decision in their pleadings.
They
When-
said you're barred by the statute of
They,
limitations.
they put in the boilerplate, plaintiff's claims are barred by the statute of limitations. And they took a chance whether that was going to subsume within that larger statement that plaintiff's claims are barred because she filed too soon.
No, they're barred by the existing, if you
You're-
go with the reading of Judge Rivera's suggesting here, one possible reading of this, they're barred by the old statute.
By the old statute would be the argument.
So why isn't that
Well-
an accurate defense?
For them, because if the old statute, it goes back to what's the effect of that February date.
Well,
I
let-
mean, it really comes down
Let me
to
ask
how do you
this.
construe
I know the
that?
red light is on,
Yes.
and perhaps something for you to address more extensively when you get back up. But what is your position on the equitable estoppel? On equitable estoppel, given what you have just said, that they made some strategic
Right.
decision that perhaps ensured that you would not be able to timely file if you discovered the premature
Right.
filing?
I did argue equitable estoppel to the Second Circuit.
Yes.
And you didn't
Yes, but they
really.
relied on a state case, so you want to argue that they've misread that, that's up to you.
Oh.
So, but
Hadn't
maybe you
really
can do that when you
prepared
get back
that
up.
issue, Your Honor, I quite frankly. But,
Well, what was your argument about the equitable?
well, the argument was that they engaged in gamesmanship, and that they made a strategic drafting decision to frame it broadly, kind of kept the powder dry, not to clue us in what was going on, and kept extending discovery during that next year because the statute got extended because of COVID, and then waited until 2 or 3 weeks after the final window closed in August 14, 2021, to file a motion for summary judgment, at which time we were, completely time barred because the final date of that statute had passed. Obviously, we're all wishing that trial counsel had filed it more timely, but that's not what happened.
So I'm just not sure of this. I read the district court opinion, and it seems the district court opinion is much more focused on equitable estoppel, I think, injustice theory and counsel error. Was the argument on this is not a statute of limitations issue made to the district court? Because it doesn't seem to really
it's
be addressed.
Quite candidly, Your Honor, that's an issue that the Second Circuit kind of surprised us with, quite frankly. I think my opposing counsel would agree. I was asked, well, is this a claim processing rule? And I was, quite frankly, I hadn't really thought of it that way. And so, now that we've, approached it from that point of view, it's a little different. What the Second Circuit wants to know from this court, of course, is it a statute of limitations or a condition precedent? Statute of limitations defense would have been preserved in their affirmative defense. Condition precedent would have been presumably preserved by plaintiff's failed to state a claim. Or is it something else? And if it's something else, then it's forfeited, is how they're approaching it.
Thank you.
Good afternoon, and may it please the court, Patrick Hines on behalf of respondents. This case is about whether the court is going to upset established notions of what statutes of limitations are in order to save one claimant from run-of-the-mill attorney error. The
With
court-
respect to a statute of limitations, does it not focus on an end date in which a case is viable?
Not always, Your Honor. Of course, statutes of limitations set time periods during which remedies can be sought on claims arising elsewhere in law. And obviously, time periods have a start date and an end date.
Well, isn't the start date usually an accrual date, not a statute of limitations date? Claim
Well-
accrual date?
A claim accrual date has to do with when the clock for the time period starts
Right,
and
and haven't we
stops.
distinguished in some of our cases between a claim accrual date, which is not a statute of limitations, and where where the legislature has set a statute of limitations, we've nevertheless said we get to decide what the claim accrual date is, often as a matter of common law?
Well, deciding the claim accrual date is when the legislature has not been specific or where there's injustice. I think there was an effort to have the court interpret the DES cases in that way, but in the Fleischman case, the court declined to do so and pointed back to the legislature to say, if you want to have a different accrual date, then it really needs to be for the legislature to decide. And here, certainly, the legislature made very clear this is the window. And when you have a statute that prescribes a window of time during which remedy can be sought, that is a statute of limitations.
So
That's
how do you
what it's-
square the language of hereby revived with your position?
A couple of answers to that. One is the statute points to every claim or civil action that is brought is hereby revived. So it's revived when it's brought, but it can only be brought during the period of time where action thereon can be commenced. Secondly, it doesn't really matter.
Couldn't you likewise read that as it's revived, now you can go about preparing for it to file it within the expiration of that 6 months?
I read hereby.
And the court being ready and trained?
Hereby revived means it's no longer subject to the prior applicable statute of limitations. That's what the legislature meant. They wanted to be clear that other statutes of limitations aren't going to apply. And in the
So
event
you
If
can
that's
bring
what
the
it
claim.
meant, then commencing before the window opens, but there's no prior applicable statute of limitations, puts it in some limbo world where, using that hypothetical we were using before, that where we posited that maybe it was dismissed under the pre-existing statute of limitations wouldn't be an issue if what you say is true.
Respectfully, I disagree with your premise. What it's saying is that the other statutes of limitations are not going to apply, and in the very same sentence, it provides action thereon may be commenced during this specific time period. That is exactly what a statute of limitations does.
So
under this
what's that
court's-
period in the window? What do you call that? What's the operative effect of that?
It is a period during which action thereon cannot be commenced because it's outside the statute of limitations.
Aren't there other provisions in the statute which provide for a later effective date?
In 214G,
I thought 214C, for example, which is training, takes effect later. I thought there were a couple of
I thought this
provisions in
one
the statute.
tied to age. Isn't there one?
so with respect to 208B, which was also
Or
added
just
at the
to-
same
if
time.
I can finish my question, I thought that there were a couple of other parts of the statute which had an effective date that was specifically set later. And if I'm right in recalling that, I might not be, then if the legislature did not specifically extend the effective date here, wouldn't that suggest that they meant the revival to take effect on the date of enactment in February?
Well, they didn't extend the effective date of the statute in that it was effective as of the date passed, but they were very clear and unambiguous about when these newly revived claims could be
Well,
commenced.
this is, I take it you mean with the phrase that starts with "and," et cetera, following hereby revived, right?
Yes.
And my question is, if in other parts of the statute, the legislature specifically said, this will take effect 6 months later, in so many words, why wouldn't it have done the same thing if it meant for the revival and the, I think, concomitant extinction of the old statute of limitations, which I think is what you're relying on? If it meant that to be kicked out 6 months, why wouldn't it have said so explicitly like it did in other parts?
Well, it's tough to answer your question, Your Honor, because I'm not particularly familiar with the other provisions of the statute that you're referring to. But, I think the canon of statutory interpretation.
Okay, I'll read the provision I'm talking about to you. It says, "This act shall take effect," this is section 12 of the act, "shall take effect immediately, except that section 9 of the act shall take effect 6 months after this act shall become a law, provided, et cetera, that the training shall commence, provided, set forth in specific sections, 3 months, et cetera." All I'm asking is, does that indicate that the legislature thought specifically about when different provisions should take effect and did not embed in there that this provision, the revival provision, would not take effect months later?
At best, I think that's an oversight and not really careful wording by the legislature.
But
I
you
don't.
could say the same thing, perhaps. I mean, which way that cuts, I don't know. It could be an oversight that the legislature didn't include that, but maybe we need to take that at the text at face value then.
Well, there's so much other context to this statute as well. I think on its face, I think if it's unambiguous in the words of the statute, we have to avoid peculiar readings or strange readings to find meaning that is not really there. And here the statute is so clear that action thereon may be commenced not earlier than and not later than. That's what a statute of limitations
Since we
does.
normally think of when you can bring a claim as either the date the claim accrues, or perhaps in this case, the date that it's revived or something like that, why isn't it, and I think your argument has been, we need to think of the opening and closing periods as reciprocal, and because the latter is a statute of limitations, the first one must be a statute of limitations. That's at least how I understood your argument. Why couldn't we more appropriately think of the first period as a condition precedent to bringing suit?
It's certainly one thing that you could characterize it as is compliance with that is condition precedent to suit. I think it's somewhat inconsistent. Because if you're saying that, if the rule is, and I think it is based on this court's prior precedent, that a statute of limitations governs the remedy and not the right, so it sets a time period during which remedy can be sought. That's the nature of a statute of limitations.
Well,
It would be
usually it terminates your ability to bring a claim at a point. We don't usually think, I mean, can you give me a case of ours where we've said the commencement period is a statute of limitations?
Well, I think we can look to the DES cases that Heimowitz and World Trade Center, which it wasn't a DES case, but similar case, where you have the legislature looking at the limitations period and saying, well, the beginning period that we've set, or the accrual date we've set, that's unfair to claimants. So we're going to adjust it. We're going to adjust the beginning period to benefit claimants, which is very similar to what this legislature is doing here.
But I thought those cases were ones where there wasn't this gap between, the effective date and the date of revival. Am I misrecalling that?
I'm not aware of any other statute in which they've had a statute passed on one date and then opened the window within a defined period of time later. I understand what you're
Counsel,
asking there.
On this question of policy, my understanding of the purpose of a statute of limitations is to allow a potential defendant to rest in repose at the end of the statute. That logic doesn't really work so well if, in terms of saying that this is a statute of limitations, because you certainly are not resting in repose as of the effective date of this statute. You're well aware that your rights may be infringed by a lawsuit that's coming in 6 months. So for me, conceptually, it's a hard fit to at least call the beginning of this window a statute of limitations.
This court has never defined the nature of a statute of limitations solely by virtue of the policy goal achieved. If we were talking about the defense of latches as an equitable defense, I would agree with you that the only purpose of latches is to prevent prejudice to the defendant. But this court has never understood statutes of limitations, a legislative act, so narrowly.
Look, I'm a little confused by this hole you're going down. I think it's pretty clear from the legislative statements that it is a revival period. That is what they call it. That is what it is. You don't have to worry about the front part, the first day, as being part of statute of limitations, because that phraseology only applies in situations where the statute of limitations doesn't have a start date. It starts with the accrual. They've already accrued. These are claims that exist. Nothing else needs to happen other than the filing, correct?
I think it's, but the point
So
is.
all I'm saying is, I don't know why you need to push this part of your argument when the legislature has given you your answer. There's a window during which someone can file a claim that previously could not be filed, and that's it. And it doesn't include the 6 months.
Absolutely. I think our primary argument is look at the text.
So if we're going to answer the Second Circuit, what is the 6 months?
The 6 months is part of the, I think that their question is inapt. It's phrased in a way that doesn't make sense, because the beginning point and the end point are the period. So to try to characterize that 6 months as this separate legal concept from a statute of limitations is simply an inapt characterization
Well,
of
the
what
6 months isn't part of the revival period. That is, it's not part of the revival period. So what is the 6 months then?
The 6 months is simply a period of time preceding the revival period during which claims cannot be commenced.
So you too are of the school of thought, perhaps, that they are not revived during those 6 months? Or does it not matter for purposes of your argument?
It does not matter for purposes of our argument. However, to answer the question, I think that it says every claim brought is hereby revived.
Well, they brought the claim.
Well, they brought the claim, however, action thereon could not be commenced except during this time period, and that is a statute
Well, there could
of
be some
limitations.
claims that were not brought, right? That was the problem, that people might not have realized or been able to pursue these claims during the short statute of limitations. So there may be claims that were never brought.
Correct. I mean, certainly, it's not something where anyone was required to bring a claim. They could let their claim go away and did not have to file a lawsuit. You know, those are judgments that could be made by claimants. So to say hereby revived has to be read along with, and action thereon may be commenced not earlier than. That is what a statute of limitations does.
Well, but here's what I'm struggling with. I think you said that you haven't identified any statutes where there is something that you would call a statute of limitations on the front end, right? Not any other statutes where there's a gap between the date on which a cause of action is revived and it can be commenced, right?
Correct.
Okay, and for example, the U.S. Supreme Court has looked at what they call claims processing rules. I'm thinking here specifically about Henderson versus Shinseki, and said this is something that is aimed at encouraging parties to take certain procedural steps at certain times, but can't extinguish their rights. And so if we don't see anything else that looks like what we have here, where there is a gap between the revival date and what the statute says about when the action should be commenced, why wouldn't we think about it in the way the Supreme Court has thought about what it calls claims processing rules, which is that it doesn't preclude the action from proceeding?
With respect to Your Honor, I disagree with your premise on what the Supreme Court has said when it's talking about claims processing rules. The Supreme Court, when they're talking about claims processing rules, they're talking about federal statutes that create rights of action and require action within a certain amount of time. Sometimes that's a statute of limitations, sometimes it's something else.
Well, I think Shinseki is a case about the time to take an appeal. It's not, I think, a case about when you can file a claim initially. And granted, that's different than what we have here, but my point is just that it's a different category of a statutory provision that the court has identified that doesn't have the same effect that a statute of limitations would have.
But it's a jurisdictional question, right? Which
Well,
is not relevant here.
Well, I think in some cases, like Wilkins, which comes after Shinseki, I think you're right about that. I think it says we have jurisdictional provisions and non-jurisdictional. A statute of limitations might be a non-jurisdictional provision. But I actually read Shinseki as different, as saying there is another kind of rule which is not a statute of limitations and which is not jurisdictional and is a claims processing rule. I don't think that provision is a statute of limitations. So I'm just asking, why could this not be, if we don't see an analog for it in our statutes, something that is likewise an unusual arrangement, but not a statute of limitations?
To do that, Your Honor, would be a rug pull, I think.
Would be a...
because- Would be a rug pull, would be unexpected by any parties who are figuring out what defenses they need to plead and how they need to do so.
I think we've agreed that there aren't other statutory provisions like this out there, so it would be sui generis, as opposed to something that would be broadly disruptive, I assume.
And I think when the court's reading claim revival statutes, under the Regina decision in 2020, the court should take a very narrow view. There should be a very explicit legislative intent. And
I
when
appreciate-
we're doing that, we should avoid.
I appreciate all that, but I just want to make sure I do understand. There aren't any other statutory schemes like this, I haven't identified any, I don't think you have, but I want to make sure, where there is this gap in terms of thinking about what the implications of considering it that way would be.
The answer is no. However, I don't think that makes this not a statute of limitations, because if the rule we're encouraging this court to adopt and basically maintain from its prior precedent is that the nature of a statute of limitations is that it sets a time period during which the remedy can be sought. That's exactly what
What about
214
Black's Law Dictionary that says a statute of limitations is a law that bars a claim after a specified period, specifically a statute establishing a time limit for suing in a civil case based on the date when the claim accrued, bars it after. So how does the 6 months fit within that definition?
I think that's an overly narrow definition of what statutes of limitations do, because
So Black's Dictionary, we should not consider that definition?
I think it can be considered, but I think based on this court's prior case law, the nature of statutes of limitations is defined as something that sets a time period during which to bring a claim. The other thing I would say is, if it's not a statute of limitations, the only other
When you
reading.
say narrow and you consider why statutes of limitations exist, there are certain rights, of course, defendants have with respect to cases being stale, plaintiffs sitting on their rights. That doesn't necessarily occur here when you're talking about that 6-month period. If, in fact, whether we create a state processing aspect, the judges have to be trained, an apparatus has to be set up to file these claims. How is that contrary in saying the statute of limitations, applying it like Black says, after, that the 6 months is just to get ready and you can still bring the claim? Why is that wrong?
Well, because the legislature here is so clearly creating a window of time during which claims can be commenced, and that the legislature certainly didn't make reference to a new legal concept. They used language that is entirely consistent with every other statute of limitations and every other claim revival statute, but for when the opening of the window would be. There's no clear expression of legislative intent to invoke a new legal concept or invite this court to create one sui generis and thereby leave parties like the district who are trying to figure out how to plead their defenses.
You started to say, if this is not a statute of limitations, the only other.
Yeah.
And then we cut you off.
What's the only other thing it could be?
Condition precedent, Your Honor. So when the court has looked at statutes, the nature of statutes of limitations and whether it could be something else, the only other something else I could identify in all of my reading of this court's precedent was a condition precedent to suit.
This seems, I think to go to what Judge Halligan was saying, to be very unique, right? And we're trying to, and the question is asking us to put this into a framework of a statute of limitations, this particular statute. But it seems to me this is not that. There are statutes of limitations here. They ran. This is a revival period. And after this revival period is over, the old statute of limitations is going to apply, right? This isn't a new statute of limitations to me, either before its effective date or after its effective date. It's a window. So it seems to me one way to read this is, if you bring this claim before that window opens, you are subject to the statute of limitations. If you bring it in this period, you can bring it. If you bring it after this period, you're subject to the old statute of limitations. Why are we and you in your argument, trying to fit this statute into some type of statute of limitations framework?
Well, because, Your Honor, we're advancing a rule that it builds on this court's existing precedent about what statutes of limitations are.
We don't have, right, and that's what I'm asking you. We don't have a statute like this. The statute of limitations is generally you have X amount of time from accrual, and that's what applies to these claims. You have X amount of time from accrual. What this statute does is not change you have X amount of time from accrual. What it does is say, regardless of the fact your time may have run under the statute of limitations, you have a whatever term period, a window to file a claim, and it will be timely in that window. And when that window shuts, it seems a fair reading, you go back to the old statute of limitations. So it didn't seems to me, one reading of the statute is it didn't create anything in those 6 months. What's those 6 months are is what the 6 months after the window closes are. That time period's governed by the old statute of limitations. This is a window that gives you relief from that statute of limitations. And that is whatever that period that you can file in. So I don't understand why we're trying to, and I know why we're trying to do it, it's the way the question was teed up for us, but why we're trying to characterize a 6-month period before you can file as this new statute creating some type of new statute of limitations.
Well, we don't argue that the 6-month period created a new statute of limitations. We're arguing that revival provisions are essentially a species of statute of limitations. This revival provision provides a start date and an end date, and outside of that provision, you don't have an ability to seek a remedy.
But that's fine as far as it goes, but as we've said repeatedly, we don't have a situation where there's this 6-month interim period, and it makes it very difficult, at the risk of just repeating what Judge Garcia just said, it makes it very difficult to fit this in the framework of what we think of as a statute of limitations. So let me just ask, what would be so wrong with just saying this is sui generis? This is a window. It's a revival window. It starts on this date, the date that the legislature said, August 15th, 2019, and it ends 1 year later, or maybe 2 years later, depending on whether there's a pandemic or not.
Because the principle this court has announced in interpreting revival provisions is interpreting any
Your
statute.
answer to that was supposed to be, yes, I agree.
Yes.
He started that date on the date you wanted started.
Yes, exactly. Yes.
There you go. It's a
I guess I
win.
misunderstood your question, Your Honor, and I
There you go.
apologize.
Counsel, I know your light is on, but can I ask, why not bring this earlier, before the window had expired?
That's a question of federal procedure, Your Honor, and the district looked at the federal procedural law governing the specificity with which defenses must be pleaded, and we pleaded, this is barred by the statute of limitations, which is all that's required. It then put the ball in plaintiff's court to make a motion to strike that defense, serve an interrogatory, asking what that's all about, and this is just plain run-of-the-mill attorney error.
But let me
They just
ask
didn't
you
do
this,
that.
I thought, this is part of my problem with your argument, that you're arguing that the revival period is the statute of limitations. So how were they to know when you had just a boilerplate sentence that you were referring to the old statutes of limitations as opposed to the revival period? Or am I misunderstanding you?
We were referring to the concept that a statute of limitations sets the time period during which you are allowed to seek a remedy. And they did not file during that time period, thus it was barred by the statute of
Yes,
limitations.
but arguably there's more than one, given that you keep referring to the revival period as a statute of limitations.
Well, we're referring to the period, the
Did
statute
you,
itself
did
as one.
you in any way state that in your assertion of its time barred, you were referring to the prior, right, the otherwise usual statute of limitations that apply to these kinds of claims, as opposed to the revival period that's set out in 214G?
We did not say revival period. We said this is barred by the statute of limitations. I
When
think
you,
whether
when
or
you
not that
moved in the
adequately.
district court on statute of limitations grounds, how did you articulate what statute of limitations was violated?
Well, we articulated that 214G is the applicable statute of limitations provision that we're moving under, and simply saying you did not comply with that statute, and therefore the claim is barred. I think the question of federal procedural law about whether we had to be more specific in our statute of limitations pleading is not before this court and is really for the federal courts to determine.
Thank you.
Thank you.
Very, very briefly, Your Honors. I think it's noteworthy that the school district council has not pointed to any authority that this kind of a 6-month waiting period is a statute of limitations. And statute of limitations, as Black's Law Dictionary defines
But
it,
that's not
it's a date
fatal. That in many ways, not fatal to their argument, because it can be, as the legislature referred to it, a window. It's the revival period, as opposed to be distinguished from the usual statute of limitations that would apply to these kinds of claims.
think I understand what you're.
right? I mean, the matter, if it is or isn't a statute of limitations, that's not what
Well,
matters. What matters is what happens in these 6 months when someone files before the window.
I think the reason what it's called is important because it goes to whether they preserve that affirmative defense or forfeited it. And that's obviously a question for the Second Circuit, not for this court. But that's why they want to know, well, what do we call this 6-month period? Is it a statute of limitations? Well, it doesn't look like a statute, that portion, that 6-month portion,
Yes, but even if
doesn't
you
look like
take
a
their
statute.
argument, right, the bald statement of it, it's barred by the statute of limitations, excuse me, and one doesn't know if they mean the one that applied pre-revival statutes or this thing that's called a window that they refer to as a statute of
Right.
limitations. The point is what happens in these 6 months.
But
right?
that comes down to.
And if that's about a premature filing, that is certainly not what they've said. That's not, right, that was not what they were describing it as.
Well, I think that.
And they were on notice that they could, because you had Geis and you already had Carlino that described it that way.
Well, I think that it's been referred to as a premature filing in this case, that they filed it before that
Yes,
window.
but what I understood they were arguing was it's outside the statute of limitations. That's why
Because
it's
they're
time barred.
taking a very broad construction of what a statute of
Yeah,
limitations
but then one
is.
would say, one would have to say the 6 months is part of the revival period, and the language is very clear that it is not.
Well, that's where I disagree, because I do think that it is part of, after it was revived. I would very briefly like to address the condition precedent issue that was raised here. And the case authority that's cited in our brief does say that when a statute does not create a new cause of action, it is not a condition precedent. This revival statute didn't create new substantive underlying causes of action. It just dealt with the time frame of it. So I think it's
So your view
inappropriate.
is the legislature could not have created a condition precedent? It's powerless to have done that?
Oh, they could have, but it
Oh.
would have to be clear, and when you're, it's not clear here. I don't think.
So if they had
that
said,
language-
here's a condition precedent to suit, you must.
Exact. Well, for example, it's not at all uncommon, particularly in the federal system where there are administrative claims, oh, you have to give, under the Administrative Procedures Act, for example, you have to give notice before you can bring an action against an agency of the United States government. So those are.
Or in line with the case law and the jurisprudence, they could have simply said, we are creating a new claim. This is a new cause of action. This is the period for this cause of action. They could have done that. It would have been very straightforward.
Right. And nowhere does it say this is a new cause of action. It refers to reviving otherwise, substantive cause, the time frame for filing otherwise substantive causes of action. So I don't think that it falls within the condition precedent rubric, basically. And those two questions of whether it's a statute of limitations or condition precedent is what the Second Circuit wants to know, because it goes to the issue of whether as a matter of federal pleading, they forfeited.
But the question is actually, is it statute of limitations, is it a condition proceeding, or is it an affirmative defense? So we
Something
actually
else.
have to get to that. Well, no, they didn't say something else. They said it was an
Well, or
affirmative
they
defense.
said,
right?
or some other
Or some
affirmative defense.
Yes, but they've got it in that affirmative defense box.
Right. But if they
And is
had,
that your position? It is an affirmative, I don't know what it is, because the front end of that question is the 6 months, so the 6 months is not an affirmative defense. Challenging the filing during the 6 months might be an
Well,
affirmative defense,
I
I
think
don't know.
if they had wanted to be absolutely certain
Yes.
that they locked down an affirmative
Yes.
defense when they were writing their answer, and they weren't concerned about tipping us off that it was filed too soon, they would have said something to the effect of plaintiff's claim
No, but I
is
mean, in
barred.
response, I understand your point there, thank you.
Because it
I
was
mean,
filed
in
too soon.
response to the Second Circuit's question. You say it's not a statute of limitations, am I correct? The 6 months.
Correct. It is a waiting period.
It's, okay. So then, is that waiting period and something that they can invoke an affirmative defense against?
Sure, but they didn't.
What would be the affirmative defense?
The affirmative defense would be that plaintiff failed to state a claim
Okay,
cognizable under the revival statute
okay.
because they filed it prematurely, and that part of your essential claim was that you file it during this window. I mean, that's a lot of words, but the essence of it would have been, and that would have put us on notice, obviously, trial counsel on notice that,
got it.
whoops, I filed too soon.
Sure.
And they didn't want to tip them off. So they made a strategic decision to keep it general, to just put in that boilerplate statute of limitations affirmative defense
Doesn't that
everybody
happen in
uses.
litigation all the time?
Sure, but they have to live with the consequences of making those kinds of strategic
Well,
decisions.
Or they would anticipate that counsel on the other side would try to figure out what it means.
Correct. But they also presumably, under Carlino and Geis, if the court had been confronted with a motion to dismiss because it was premature, likely would have dismissed it without prejudice, and we would have filed it within
But
the
wasn't
statutory
counsel
window.
on notice given Carlino and Geis had been decided? I mean, it's decided before the window closes, those two cases. Or am I incorrect about when those cases were decided? I thought that was the whole point.
have the dates
They
here.
said it's dismissed without prejudice, go file it within your window,
Yeah.
right? So counsel, right, could have been aware of those cases and said, aha, maybe I've got a problem.
Well, I mean, the statute kind of should have clued him in as to when he filed. He was looking at the wrong provision in the statute. And if you read the briefs that
Well,
trial
that
counsel
explains.
filed, there were other
Yeah, but
reasons,
that
personal
explain-
reasons why he
Yes, that
did it.
explains the mistake,
Right.
right, or the error, whatever, of when they file, the filing before the window opens. It doesn't explain what I thought you were focused on, which is, once the school district asserts that it's time barred, counsel not being put on notice that their real argument is that it's premature, as opposed to it's barred as in it's barred because it's exceeded the time frame available. I thought that's what you were talking about.
Well, I think by the time they filed for summary judgment, there was no way to fix the problem. Because it was, by then it was time barred by the end date
No, I'm
of the statute
talking
of
about
limitations.
the answer that says it's time barred. But I thought you were arguing that's what didn't put them on notice in time. Did I misunderstand you?
Well, if they had in the answer been more specific, we would have
Yes.
been alerted to the fact that there was a problem. I guess that's what I'm trying to say.
Thank you, counsel.